Well, we woke up this morning to a hard decision that the California Governor Newsom, is going to have to do in his continued fight against Donald Trump trying to take over the National Guard in California, because he's on the wrong end of a decision 3-0 by the Ninth Circuit Court of Appeals, a 3-judge panel of the Ninth Circuit Court of Appeals that said that effectively, under long-standing Supreme Court precedent dating back to 1827, that a president has the right on his own initiative to federalize the militia of a state with very little to stop him, that it's his first interpretation that is right, and that the courts must give a, quote, highly deferential view of that decision to allow that presidential proclamation to federalize the state troops to stand. Once you go down that road, and they did it 3-0, even though there was one Biden appointee, Judge Sung, once you go down the road of highly deferential to the president's decision, then you don't really have to worry about what I was concerned about. What I thought the more proper result would have been here is that they sent it back to Judge Breyer at the trial court level with instructions to develop more of a record of facts. But they cut the legs out from under that procedure because they said, well, the first instinct that a president has in federalizing the militia, we have to be highly deferential to, citing that case of Martin versus Mott from 1827 involving James Madison, President Madison's decision to federalize the New York militia. And they said that's still good law, it's still on the books, and that is their guiding principles. They did give Donald Trump a couple of losses, as I had hoped. They said that ultimately the court has the right to review the president's authority, the president's conduct in this area. He exercised his powers under the 1903 Militia Act, which we call 12406, and found there was either a rebellion or what the panel said was an inability to properly exercise the laws of New York, of the president, because of the attacks on certain buildings that they credited in the record in making their decision. But they said, yeah, we can review it, so it's justiciable. So they rejected Trump on that. We don't see it as a political question, meaning we can't review it, but we're going to be highly deferential to whatever you say based on this 1827 case of Madison versus Mott. And the other thing that we sort of hung our hat on and thought they would give more credence to is the requirement in the Militia Act that the governor be involved in the order. Well, they said, yeah, it says through the governor, but we don't interpret that to mean that the governor has a veto power. We know that the governor was cut out of this process, but orders were given by Trump to the adjutant general, who is the the National Guard officer at the highest level, who is an agent of the governor. So we think that's good enough. He got the order from Trump. Yeah, we're going to do it. Now look, I'm going to cover in the second part of this hot take. Here on Legal AF, did I mention we're on Legal AF? This is why you got to be here. Yeah, I had hoped for a different result. I gave a path for a different result. But listen, we don't blow smoke or sunshine. You're here on Legal AF. Hit that subscribe button and help us continue to grow our pro-democracy channel. Here's the decision that Gavin Newsom has to make, and I'll update it throughout today on Friday. Does he go for what's called an en banc decision of the Ninth Circuit, requesting that all 29 of the members of the Ninth Circuit Court of Appeals sitting in San Francisco, not just the 3 that were randomly assigned this case, Miller, Bennett, and Sung, all 29 take a look. If of the 29, he gets 15 of them to believe there should be an en banc decision that this panel got it wrong, he's got to get 15 of the remaining, let's say 26, because 3 voted against. So he's got to get 15 out of 26, a little bit more than half, to say, yeah, we think this is interesting. We want an en banc decision. Then they put together, and in the Ninth Circuit, it's a little bit more, it's unique. They put together a panel of 11 total, the chief judge of the Ninth Circuit, and 10 randomly selected justices from the 29. It could be some of the same people who were in the original panel. But they put together this panel of 11. What's the advantage to it? It would give an opportunity for Gavin Newsom to get a win before somebody takes it to the United States Supreme Court. Because right now it's a loss. The downside, he gets a second loss. And now it's of the entirety of the Ninth Circuit. Now, those that practice there regularly, I've argued cases there, but those that practice in the Ninth Circuit, including on our own network, have said they think that the Ninth Circuit, given the makeup of it, which leans liberal to moderate, is going to rule against Trump. But, I also hope that this 3-judge panel would have sent it back to Judge Breyer for further record development, factual development, and that didn't happen. So that we could try the en banc. It's not a requirement that you try en banc before you go to the United States Supreme Court. Otherwise, Gavin Newsom either has to take an emergency application to the United States Supreme Court, hope they're interested. It would come up through Kagan, who's the first justice on the train stop. She would then refer it over to the full 9. And if they get 4 or 5 people that think it's interesting, it'll come up for review on briefing by the United States Supreme Court. They may find it interesting. They may want to weigh in on this Martin versus Mott case from 1827, or they may not. But I don't think he has a choice. I seen some commentary out there where he might make bad law, so maybe he'll just leave it alone. I mean, it's already bad law. He's got a Ninth Circuit Court of Appeal in his own state that'll be used by other against other states when Trump does this in New York and in Illinois and in other places and all the blue states. There's now Ninth Circuit precedent that will be cited in this 38-page decision, unanimous. I don't think he's got a choice, but these are the decisions, the hard decisions that they get paid to make. And I get not paid to kibitz about and make commentary about. So Rob Bonta, who is the Attorney General for California, in consultation with people that are expert on appeals. And of course, Governor Newsom makes the final call. Is going to have to make that decision quick. I think it's going to be a today, tomorrow decision. We'll report on it right here on Legal AF. You're here already. Take a receipt. Hit the subscribe button. Help us continue to grow this pro-democracy channel. Legal AF, the Substack. I'm going to post the 38-page decision this morning. You can pull it from Legal AF Substack and read it for yourself, and we'll continue to update you here and on the Midas Touch Network along the way on this fast-moving and important story. Last word, there was going to be a hearing today before Judge Breyer on the next step up on the temporary restraining order, which is the preliminary injunction, but that's off because they've granted the stay. It's interesting. It came up on a temporary restraining order, which really the court didn't have jurisdiction, appellate jurisdiction. They should have waited until today when the hearing on the preliminary injunction was conducted on a full record and then take the case up. But they took it up early because that's what they do when they want to reverse engineer back into a decision, the two at least Trump appointees. And now they've stayed the entire case, stayed the entire order. It doesn't just say temporary restraining order. It says the order pending appeal. So they're going to let this case go through the whole appellate process, but they have said out loud that they think it's more likely than not that Donald Trump would prevail on the underlying merits of the appeal. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states. lawsuits and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.